What is a covered legal entity under the 2026 rule? Why entity structure is the real trigger. In Section 2.1, we defined covered residential real estate. Now we move to the second half of the reporting trigger. Who is purchasing the property? Property type alone does not activate the 2026 FinCEN reporting requirement. The ownership structure is the true pivot point. The 2026 rule primarily applies when residential real estate is purchased by a legal entity rather than an individual natural person. That distinction is foundational. If John Smith purchases a home in his individual name with cash, reporting may not apply. If John Smith forms Desert Valley Holdings LLC and that LLC purchases the identical home with cash, reporting may apply. The property has not changed. The price has not changed. Only the ownership structure changed. That change can trigger federal transparency requirements. What qualifies as a covered legal entity? A covered legal entity generally includes limited liability companies, corporations, whether C Corp or S Corp, limited partnerships, general partnerships, certain trusts, foreign entities registered to conduct business in the United States, and shell companies formed primarily to hold assets. Arizona investors frequently use LLCs because they offer liability protection, pass-through taxation, asset segregation, and privacy advantages in public filings. However, that element of privacy is precisely what federal regulators aim to address. Transparency, not prohibition, is the objective. Arizona-specific context, LLC popularity under ARS Title 29. The Arizona Limited Liability Company Act. Forming an LLC is relatively simple and cost-effective. Historically, Arizona did not require the same level of public disclosure of members as some other states. This made Arizona LLCs particularly attractive for rental portfolios, short-term rental structures, and asset protection planning. Beginning in 2024, the Corporate Transparency Act, 31 U.S.C. par 5336, required many entities to file beneficial ownership information directly with FinCEN at formation. Now, beginning March 1, 2026, if that same LLC purchases residential property without traditional bank financing, an additional reporting layer may apply at closing. Formation reporting and transaction reporting are separate obligations. Trust structures and reporting trusts introduce complexity. A revocable living trust created for estate planning purposes may be treated differently from a business trust created for anonymity or investment structuring. When a trust is used as an investment vehicle for holding residential real estate, particularly in layered ownership arrangements, reporting may apply. Arizona agents must not attempt to interpret federal trust law or advise clients on structuring decisions. The correct professional response is straightforward. Because the transaction involves a legal entity, the settlement agent may require beneficial ownership disclosure under federal law. Neutrality protects you. Foreign beneficial ownership. FinCEN has historically focused on foreign capital entering U.S. real estate markets through domestic entities. Consider this scenario. A foreign national forms Sunset Rentals LLC in Arizona. That LLC purchases a Scottsdale property with cash. The entity is domestic. The beneficial owner may not be. The reporting framework is designed to identify the ultimate human owner behind the purchasing entity. Agents are not investigators and are not responsible for immigration enforcement. However, they must understand how ownership structure triggers federal transparency review. What is not a covered entity? Purchases made by individual natural persons, married couples purchasing jointly, joint tenants, or sole proprietors buying property in their personal name generally do not trigger entity-based reporting unless other unusual factors exist. However, Arizona agents frequently encounter assignment strategies. If an individual places a property under contract and later assigns that contract to an LLC prior to closing, the structure changes. That change may affect reporting obligations. Structure modifications, even late in escrow, can alter compliance analysis. Shell companies and layered ownership. A shell company typically has no active business operations, no employees, no physical office, and exists primarily to hold assets. Layered ownership may involve one LLC owning another LLC, which then purchases property, while the parent entity is controlled by a trust ultimately controlled by an individual. The 2026 rule seeks to identify the ultimate beneficial owner, the real human being behind the structure. Chapter 3 will examine beneficial ownership definitions in depth. Arizona broker supervision implications. Under AAC R4-28-1103, designated brokers must exercise reasonable supervision. If your brokerage regularly handles investor LLC purchases, wholesale assignments, portfolio acquisitions, or short-term rental entity transactions, agents must understand when entity structure triggers reporting. Agents cannot advise clients on avoiding federal reporting requirements. Agents must coordinate with title companies and settlement agents. Regulatory awareness is part of reasonable supervision. Transition to Section 2.3. You now understand covered property types and covered legal entities. The final trigger component involves financing structure. Even entity purchases may not trigger reporting if traditional institutional mortgage financing is involved. Section 2.3 will define how financing determines whether reporting is required.